Gentlemen, gentlemen and ladies and gents, got a couple of things we's gonna be talking about. You eyes, Wheezy and Georgie, because we got to bring this to y'all attention. I told you about this document. Now, see, ladies and gentlemen, as I told you, I have a lot of PDFs on my computer, a lot of information on my computers that I have never looked at. Why? Because people send me stuff all the time. I've had this since about 2011, and they just sit there until I use my computer like Google. And see, by using my computer like Google, I EEON'd some information on a computer, and this one pulled up: jurisdiction hyphen another hyphen venue or view. And if you pay attention, this is from Freedom Law School. Freedom-school.com. Now, I'm going to read to you what the gentleman says. Now, do I put weight behind this? Of course not. You're going to have to do your own research, but I find it truly amazing. See? Something truly amazing. And so I thought I'd bring it to you because I didn't tell this to these people. I have not studied the same thing they studied. I just understood just by reading the law what's going on. Now the person says, now I'm going to tell you or reveal to you something truly amazing. The federal administrative courts, that's right, they're administrative. They're not judicial. That means they're executive branch. Court system lacks subject matter jurisdiction. Now, if you want to know what subject matter jurisdiction is, basically go and do your research. I ain't got time for that. Anyway, on all criminal charges used today. Now, hold on. He said on all criminal charges used today. No. All application of statute used today. Statute and code. Now, again, do your research. In other words, every man, every woman, citizen incarcerated today has a legitimate, what's legitimate? It's not you, son. No, you're not legitimate. You're illegitimate. That's right. Your father told you that, didn't he? Anyway, has a legitimate challenge based upon lack of subject matter jurisdiction. If enough of them learn how to mount such a challenge, yes, that means you must challenge jurisdiction. You don't have to specifically say subject matter jurisdiction or in rem jurisdiction or personam jurisdiction. Those are the three major jurisdictions, people. But remember, they also lack original jurisdiction because they cannot hear cases in original jurisdiction, which is common law. Every law on the books will be overturned. No, it won't. Of course, the basic common law crimes involving injuries to another man or woman, i.e. murder, burglary, assault, rape, arson, etc. would remain crimes, but the endless stream of regulatory crimes would disappear, and they should. Regulatory, i.e. commercial crimes, ladies and gentlemen. The enactment clause. He says enacting clause, but enactment clause. Every state's constitution except Virginia, Pennsylvania, Georgia, Delaware, and the federal constitution mandates that an enactment clause be part of each and every law properly enacted by the state legislature. Look, ladies and gentlemen, let me explain something. They mention the so-called federal constitution. Let me explain to you what the enactment clause of the federal constitution is. It is the Northwest Ordinance. Go back and read it. You'll see how the Constitution could not come about without the Northwest Ordinance, and all the laws pursuant thereto must be in compliance with the Northwest Ordinance. Sorry, there'll be some judges out there that will sit up there and debate on that, and I'd be sitting up there saying, okay, go ahead and prove it. Go ahead and prove that the Northwest Ordinance is not applicable, because you get rid of the Northwest Ordinance, you get rid of the authority by which the Constitution was enacted. You don't believe me? Go read it, ladies and gentlemen. Remember, everybody wanted to talk about we're under the laws of the Confederate because they haven't read the statute. They've just been mouthing what they've been hearing people say. The so-called Confederacy was removed with the Northwest Ordinance. That was intentional. Why? because the so-called Confederacy was temporary, just like people read the Northwest Ordinance and think it's temporary. No. The Northwest Ordinance was put in place so as to bring about the Constitution. And that's why the Constitution, hey y'all, we just got paid. Oh yeah. Sorry, I like this song, ladies and gentlemen. And I'm sorry, those of you who wasn't around at the time, when this song came out, it could not have come out at a better time. Okay? It could not have come out at a better time. And so when he let y'all know he just got paid, and he's gonna step out, that's when all that clubbing and junk was going on. But I wasn't listening to this song because of no clubbing. I was listening to this song because I just got paid. You know what I'm saying? Alright, let's continue. Up the sound. Sorry, I like the song, people. Notice what he then tells you. In the case of the 4 states and the federal government whose constitutions lack the mandate, state and federal Supreme Courts, well, he says state and federal Supreme Courts. There's only one Supreme Court, ladies and gentlemen, on the federal level. So, states and the federal Supreme Court have consistently ruled that an enactment clause is nevertheless a requirement for any properly enacted law. It doesn't matter what the court rules, it matters what the Constitution rules. Look, Constitution says that Congress can, because there is an enactment clause in Congress, it requires 2/3 Congress. So, but the, the Constitution Bill of Rights doesn't include an enactment clause. However, yes it does. It says Congress shall make no law without these requirements in it. See, every law must have due process. Every law cannot infringe or abridge your rights, your freedoms. Pay attention. That's what the Constitution says, but nobody brings this up. I've been talking to a couple of attorneys lately and been telling them about how most attorneys don't deal with the foundation. Ladies and gentlemen, the foundation, how means everything. Wow! Sorry, it's a nice song. All right, most people don't consider the foundation. Ladies and gentlemen, without the foundation, and the foundation of everything is balance. Without balance, there is no life. Life cannot exist without balance. You cannot exist without balance. The laws cannot exist without balance. For instance, if you had one law that says that you cannot drive over the speed limit, and then another law that said that you can't drive under the speed limit, then the law would require you to be perfect. And you would never be able to hit your brakes under any circumstances. I.e., there must be a balance in law. Say ho. Whoa! All right. I'm going to continue. These and countless other Supreme Courts, state Supreme Courts, have further ruled that any law that lacks a required enactment clause is void on its face and need not be obeyed. Now, I am aware of these case laws that the court has said that. However, they need to be obeyed only because you, pay attention, acquiesced. Now, an enactment clause is the portion of law, rule, or regulation that identifies the relationship between the lawgiver and those who are expected to obey. And then he puts an example in here where it says, I am the Lord thy God. Okay, that's not what he said. He said, and see that Lord, that's not even a direct quote. When you got that in the King James Version, it's in all capital letters. Don't let me pull up my Bible, Discover, and show you where it's all caps, okay? All right, so we ain't going to do that. Look, if you're going to quote something, quote it correct. Okay? All right, let's finish. We don't care about any of this, okay? Hear ye, hear ye, hear ye, His Most Royal Highness and Excellent Majesty, Emperor of the Irish Republic, Lord Duke of Wales, King of England, and High King of the British Isles, does hereby decree. Okay. This is an enactment clause. It lets you know where the law is coming from, who is authorizing the law. Okay, and if you are a subject of that particular so-called monarch party, then you are by all means to obey that law. You are bound. You are a subject to the jurisdiction, i.e. subject matter jurisdiction. Sorry, that's what it means, people. Now, conversely, if the citizen is not a subject to the authority of the law given, i.e. if you are not a taxpayer, then you are not subject to the tax code respecting taxpayers. Sorry, I'm just telling you what it is, what the law is. Look, ladies and gentlemen, we run into a lot of times where they apply things to people only by presumption, because they came up with this thing called presumption of law, which kind of binds people without their, y'all know Guy, don't y'all? Groove me! They kind of bind people to things without the people's consent, without the people's knowledge, and as long as the people don't speak up, it becomes law. So all of those enactments, all of those statutes, the people didn't speak up. So they became law by acquiescence. Sorry, it's just the facts. Look up presumption of law. So what do? You challenge presumption of law as being unconstitutional because, however, nobody pays attention to the fact that a fact is a fact. But a theory could never be a fact. It's not based on a hypothesis. And because it's not based on a hypothesis, it is not fact. Well, the law can only be based on facts and conclusions and not presumptions and assumptions. I.e., people will say, well, the law presumes this, and the law does not presume anything. Okay? The law can't presume anything. The law does not have the ability of presuming anything. Okay, for instance, when you have in scripture, thou shalt not murder. Okay? Did that include animals? But guess what? There was another clause in that act which permitted the slaughtering of animals for consumption, for sacrifices. There were exceptions to the rule. But, however, if somebody thought they could just needlessly kill animals just for sport, you know, like these men, they go out hunting and they just shoot and kill things just for sport. No, that wasn't permitted under the law. There were provisions in the law that prohibited that. Okay? Chopping down a tree just to be chopping it down? Couldn't do that, people. There were provisions in the law that prevented that. So there was no room for you to come up with technicalities. Okay, let's continue. The statutes used to regulate American citizens lacked enactment clauses. No, they don't. Because you'll see that the code, USC Title 18, USC Title 5, USC Title 4, USC Title 26, USC Title 17, USC Title 11 to the Title 7, Title 9. You'll see all of those titles at the very beginning of the title. It tells you who it was enacted by. You don't believe me? Just go and look at the code. Go to the very beginning. Don't go to the statute in the middle. Why would you go to the middle? Why would you start from the middle of the book? Look, if you don't know where you've been, you won't know where you're going. So you can't start from the middle. You have to start from the beginning. So and that's why I tell you, you got to do your own research. Okay? Why you want to talk about me? Tell me why. He's asking y'all a question, y'all. Okay. Ladies and gentlemen, just take the time and go and look at the U.S. Code. Look at the very beginning of the code. You'll see it tells you who's enacting the code. The statute at large.
By Congress assembled in General Assembly, be it enacted, and be it brought forth, and be it ordained, be it ruled, blah, blah, blah.
At the beginning of each one of the laws, the codes, the titles, people, you'll see that it tells you who's enacting it. So they all carry an enactment clause. Hold on now. We ain't finished yet. This ain't killing what they saying. This is supporting what they're saying. Okay? Now, pay attention. Notice what they say. The statutes used to regulate the American citizens lack enactment clauses. Every state uses its revised statutes, and the federal government uses the United States Code as law. Now burn this into your brain. Neither the United States Codes, not true, nor the state revised statutes contain enactment clauses whatsoever. That's not true, ladies and gentlemen. They do contain an enactment clause. You see, the enactment clause covers the whole section, not just a particular section that they... Okay, first of all, let me see if I can explain it better this way. The hear ye, all subjects of the royal realm. Okay, that right there does not need to be spelled out every time you get a different point in that particular decree. Law. Okay? My prerogative. Okay? Ladies and gentlemen, they did not have to say every time they made a statement within that decree, hear ye, the royal blah, 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 blah. Do you know how long and audacious that would be? It wasn't necessary. The enactment clause is at the very beginning. But pay attention. But how do they get to do that? Because they get to amend, they get to revise. Revise statutes. Okay? So here is the problem if people were to read this and not have a basic understanding, which is why I'm showing this to you, because you got to do your own research. Okay, now watch, hold on. If you have been following this material, you have begun to see that what I have just said means that all current federal and state laws are void. No, this is not absolutely true. It means, and see, this is a statement. So we don't follow statements and stuff like this, not unless they can prove it. What they haven't done is they haven't put the cover page in here. You're going to see in a second. It means that federal and state administrative courts lack subject matter jurisdiction to hear any matter based upon the United States codes and state revised statute. Check out the inside cover page of any state revised statute in U.S. Code volume. You will find a copyright notice. You cannot copyright a public law. No, they're not copyrighting the public law. They're copyrighting the rights to put together the code in a cohesive volume. But you're right, you cannot copyright public law. Okay? And it's not the government who's copyrighting that, it's the publishers of the book. See, what they're saying is you cannot take what they put together in a book and then go and publish it yourself. Why? Because you publish it yourself, you make a mistake, then someone is liable for that. That's why they do that. But enough about that. This means that all of these codes, revised statutes, are bodies of private law or corporate law. Technically, it doesn't mean it that way, but it is the truth by saying that these are private laws, that these are corporate laws. How do you know? Well, because of the capacity that Congress enacted these laws. Title 18 was enacted under Congress's so-called corporate capacity. How do you know that? Well, because Congress became a corporation in roughly about 1928. The U.S. codes were enacted roughly about 1928 after they incorporated themselves. See, once they incorporated themselves, what they would have to do every time they enacted a law, they would have to notify everyone that they were not acting under their corporate capacity, but were acting under their constitutional capacity. Now, they say they're acting under their constitutional capacity, but what they often mean, because most people don't pay attention to the technicalities, is that they're acting under their constitutional capacity to be a corporation, because the Constitution permits corporations to exist. Okay? So when they say they're operating under their corporate capacity, remember, each of these corporations use the name of the sovereign. You cannot utilize the name of the sovereign. You can't impersonate the sovereign. So when they are not operating in their sovereign capacity, including the courts, when they utilize the name of the sovereign, they're violating the law. But nobody tells nobody this. Nobody argues this point. So if you want to bring up something about subject matter jurisdiction, say that they weren't acting in a judicial capacity, in a judicial branch of government capacity. That Congress, when they enacted the law, was not acting in a legislative branch of government capacity when enacting the law, but were enacting the law in a quote-unquote corporate capacity. Let them prove that they weren't. Let them prove that they did not file a comprehensive annual financial report. Remember, the government cannot be taxed. The sovereign cannot be taxed. Just type in that phrase. Don't go by what the people were saying. You are sovereign. No, you are not sovereign, mother. Okay? Don't go by that stuff, but go by the fact that the sovereign, the government, cannot be taxed. So why are they filling out tax reports, i.e. comprehensive annual financial reports? Those are tax reports. The government can't be taxed. That lets you know they're operating as a corporation. Okay, you can't enact laws as a corporation that apply to the private citizen, the non-taxpayer. Just letting you guys know the facts. All right. If you are not a member of the corporation that's identified by your possession of a non-required Social Security taxpayer identification number, then its laws do not apply to you. Don't do that. Don't go in there saying that law don't apply to me, especially when you submit to the jurisdiction. We're going to talk about that again in a second. You could overturn any conviction proceeding, any action brought against you by the state or federal government. A motion to dismiss for lack of subject matter jurisdiction cannot be denied by the court. Yes, it can. They do it all the time. If the law in question lacks an enactment clause, ladies and gentlemen, the law does have an enactment clause, but however, you challenge the enactment clause as being unconstitutional and invalid and void of effect, but you'll never win this. This case will never be decided on a broad scale nor on its merits. Why? Because they can't. You know how many cases will be overturned? Ladies and gentlemen, this is my boy Prince. Right now. Because he cares, y'all. If he never gets to do those things, well, he'll never get to do those anytime soon. Anyway, sorry about that, bro. Anyway, ladies and gentlemen, let's get back to this so that we can explain to you. The people who put this together, he wasn't trying to do a thesis, okay? He was just trying to put something together. That's why he didn't put his name on it. Why? Because this advice here, this doesn't explain to you that each one of those acts do have an enactment clause. But you challenge the enactment clause because they weren't under the proper capacity to enact the acts. And that the courts are not in the proper capacity to hear a challenge and or matter concerning the act concerning a private citizen. Okay? All right. It says, for more detailed explanation of enactment clauses, including a 17-page motion to dismiss for lack of subject matter jurisdiction, he tells you, I suggest The Authority of Law by Charles Wiseman, Wiseman Publication. So he says it has a motion there. Here's the problem, ladies and gentlemen. Add the information that we just talked about and see if you don't have a little bit more success. Okay? So here's the thing, ladies and gentlemen, when you get to people talking about treachery and treason and all that, stay away from those comments. Don't pay attention to those comments. Okay, those comments, most people going in there don't know what they're doing when they bring up treason and all that stuff. It don't work like that. All right? Okay. And no, you are, see this, he says, just remember, it's simple, precept of law. If you are outside of a law's jurisdiction, a law does not apply to you, and you may ignore it or disobey it with impunity. Ladies and gentlemen, no, you can't. Because of presumption of law, they presume that you are a citizen. You get an automobile and it's registered with the DMV. Okay? What I would suggest that each of you do, especially if you have an automobile registered with the DMV, that you simply send them a notice of change in terms of contract, and you let them know that your vehicle is your vehicle. You can utilize the word vehicle, automobile, however you choose. It's your choice. They don't get to define your private property. You let them know that this is my private property. It is construed as non-consumer goods, and if I utilize it for business purposes, I will place a sign or placard on the vehicle during such use which says for commercial use and consumer goods. Okay? To announce to you and all your officers that I am operating in commercial or commerce. Just that simple. And let them know that if this is not the proper way to notify them, then they need to show you how to register your automobile and how to utilize your automobile without a driver's license and subjecting yourself to their jurisdiction. That's the basic information your letter will need to contain. Do not put 18, 20, 30,000 pages. Look, New Hampshire just came up with a law approved by its Congress and its Supreme Court and the governor, signed into law several months ago. Do yourself a favor. When I say several months ago, about 3 months ago, do yourself a favor, look up that New Hampshire law. Okay? When you look up that New Hampshire law, take the wording of that law and incorporate the wording, the pertinent parts, into your letter. The letter should be no more than a page and a half long. If you do 3, 4, 20 pages, ladies and gentlemen, nobody's going to pay attention to that junk. So don't do that to yourself. Don't do that to them. Now, got to clear my throat. Let me clear my... Anyway, we're going to bring this. Come on now. I used my voice recognition software and took that law and put it here. Okay? Now we're going to explain that law. What law? Oh, you guys you're not paying attention. This is a continuation from the video done yesterday. I do continuations. It is an elementary rule of pleading that a plea to the jurisdiction is the first in the order of pleading. Pay attention, the first in the order. And that any plea which refers to the court, any other question, is a tacit admission that the court has a right to judge the cause and is a waiver to all exceptions to the jurisdiction. Okay, so we're going to explain that law by using the very wording of the law. Well, not law, case law. It's not law. All right. Whenever it appears upon the record that the court has no jurisdiction, subject matter jurisdiction, personam jurisdiction, and or, see, they explain subject matter jurisdiction, personam jurisdiction, or in rem jurisdiction. Where's in rem? In rem. I don't see in rem. I don't see in rem jurisdiction, y'all. Oh well. Those are the three major jurisdictions: subject matter, in rem jurisdiction, and personam jurisdiction. They forget about original jurisdiction. The court must have original jurisdiction to hear a matter. If they do not have original jurisdiction, then they must have your consent, either through a license, a subscription to license, or your acquiescence. Okay, let's continue. Nothing which the parties may do or omit, leave out to do, will give it jurisdiction, the court jurisdiction. But where the want of jurisdiction, there's that phrase, want of jurisdiction, may exist consistently with the record, the court record. All rise. The court is now in session. Somebody is taking minutes, people. They're on the record. A plea to the action is a waiver to any exception to jurisdiction. See, they say when you plead, you can't challenge jurisdiction. That's what this court was saying. Not true. Jurisdiction can be challenged at any time, even on appeal. Now, we were telling people to plead innocent, but you don't want to plead nothing. We were telling people to plead innocent because they don't have any procedure for a person who pleads innocent, but they do have a procedure for a person who pleads. So let's take both of these right here, okay, right here in front of us, and let's see what we can do with this. It is an elementary rule of pleading that a plea to the jurisdiction is the first step. See, that's me. I added that. Let's do that. Every time I add something, we gonna highlight it, okay? We gon' What if she don't want him? What if she don't want you neither? Hold on. She don't want none of y'all. If she chooses you, she got problems. I should have did this earlier, but we want to let y'all know where the highlights are, okay? All right, and then we'll do this one. Yeah, might as well do this one now. Now, while I'm doing this, I would suggest that some of you do like the others are doing. They're reading ahead because they don't want to wait for me to explain it. They think that they can read ahead. You know how when you were in school? Now, don't read ahead, children. No, it's because I'm going to explain everything. You read ahead, you're going to get the wrong misunderstanding. And when you get the wrong misunderstanding, you have problems. So we don't want none of y'all having problems, okay? Ladies and gentlemen, there are so many things going on. We got a couple of things we're going to talk about after this concerning our world and what's been going on in our world. And some things that I think that all of you, if you pay attention, you will better understand what's going on in the political arena. Now, as one of Jehovah's Witnesses, I don't vote. I don't get involved in politics. Well, technically, to let you all know so that you get it, I can't stand politics. Okay? Because it's stupid. Why would you want to listen to a bunch of liars? These idiots make all of these promises that you, their grandmama, their uncles, their aunties, their cousins, their nieces, their nephews, everybody and their grandfathers know they can't keep. We know that they can't keep. The Republicans promised y'all no new taxes. They lied to y'all. And y'all sat up there and y'all listened to them. Because the Republicans are not about raising taxes. Only the Democrats raise taxes. The Democrats want everything for free. They want you to pay for everything. But the Republicans want subsidies, and they're lying to you guys, and you guys are allowing them. Again, I don't vote. I don't get involved. Well, if you don't vote, you don't have a right to say anything. Excuse me, where did you get that idea that I don't have the right to say something if I don't so-called vote? Your vote don't count? You think the people of America voted that man in office? You think they voted Bush in office? You think they voted Clinton in office? You think they voted the former Bush in office? Do you think they voted Reagan in office? Ladies and gentlemen, y'all are not paying attention to what's really going on, but we're going to talk about that in a minute. Now, let's get back to this. It is an elementary rule in pleadings when you plead in the court. When do you often plead in a court? At arraignment. You're here for arraignment only, and the court is here to enter a plea on the record. Why? Because it's the initial step. It's the very foundation, elementary. Isn't that the foundation of your learning? The elementary? So the foundational rule of pleading, that a plea to the jurisdiction is the first, see, I added step. That's why it's called an arraignment. In the order of pleadings. That's why they do an arraignment. Go and look at the Constitution. Do you see anything in there about an arraignment? So where did they do that? Where did they add the arraignment jump? Statutory law. There you go. All right. And that any other or additional plea which refers to the court any additional proof and or acknowledgement other question is a tacit admission. See, anything you do after that, you've already admitted that the court has the right or jurisdiction to judge the cause, i.e. subject matter jurisdiction, and is a waiver of all exceptions, i.e. acquiescence, whereby no challenges can be allowed respecting to the jurisdiction. So you don't get to challenge the jurisdiction after you sat up there and submitted yourself to the jurisdiction. That's how they get their jurisdiction. But then you bring up that, no, I was forcibly brought here before this body. I was commanded to be here without the court having jurisdiction. So you challenge the first instance in its instance. Then you challenge the fact that the law was enacted by the legislator under its commercial capacity. Its business, what is the word? Commercial business capacity. Commercial business engaging capacity. They understand what that word means. See, their comprehensive annual financial reports prove that they, that's Betcha by Golly Wow by Prince, ladies and gentlemen. They're engaging in commercial business, and the CAFRs, the CAFRs, the comprehensive annual financial reports, prove that the courts engage in commercial business. And anytime government engages in commercial business, it abandons any and all claims to sovereign capacity and is to be treated as any other public citizen, public entity. Okay? Whenever it appears upon the record that the court has no jurisdiction, i.e. in want of jurisdiction, that is a legal term. So let's highlight in want of jurisdiction. Nothing which the parties may do or omit will give it, that is, jurisdiction to the court. Wait, hold on a minute. So they're in want of jurisdiction. Oh, look, but where want of jurisdiction may exist consistently with the record, fingerprints, presumptions, assumptions, photographs, affidavits, where a person puts an affidavit or a statement on a record where they, at the arraignment, somebody testifies like the prosecution, you have to object. I object. There's no proof. That in order for them to say that, there has to be proof on the record. And if it's not proven, the court can only hear facts and conclusions of law. They cannot hear presumption and assumptions. See, that's when you challenge. You have the right to do that. Or when they introduce documents and statements at arraignment. I'm sorry, no, you cannot do that. No, you don't get to do that. You don't have my permission to do that. I'm not sitting up here offering up no plea. Pay attention. A plea to the action, either entered by the court or by counsel, attorney, or by a party. A plea to the action is a waiver of any exception to the jurisdiction. I.e., that's what I.e. means. That is, the party waives his right and submits to the jurisdiction of the court. Don't let them enter a plea in your behalf. You have to challenge that. If you want to know how, go back, listen to the video done yesterday. Now, ladies and gentlemen, we're going to shut this down. We're going to call this document by this phrase. Elder Barge, I didn't know. I downloaded his album, so, but yeah. My thinking is El DeBarge, just like Deborah Cox, a lot of the music by the industry chosen for these artists is the wrong music for them. And I believe that that's done on purpose because they cannot allow them to grow as big as they could be. I may not be able to. Wait, hold on. We do it this way. It may not let me because I have the. Oh, it allowed the parentheses. See, normally it doesn't allow you to do parentheses, but it allowed the parentheses. So now I save that. Now let's talk, ladies and gentlemen. I did a video the other day. I put it up on Saturday, and it's where I was letting you all know what's going on regarding Donald and his tariffs. Ladies and gentlemen, many of you guys are not paying attention to the tariffs. So let me let you know about the tariffs. We're going to let El DeBarge go because, oh, come on now. See you later, El. Ladies and gentlemen, let me explain to you what a tariff is. A tariff is a tax on a foreign country. That's why they're called tariffs and not taxes. Why? Because they can't let you know that they're taxing a sovereign. But the reason why they get to tax the sovereign, because they're doing trade. That's commercial business. So that's what allows them to tax the sovereign. Because when a sovereign is doing commercial trade, he is operating in a corporate capacity. Remember, whenever government engages in commercial business, they are to be treated as any other corporation because they abandon their sovereign capacity. This is not just some Clearfield doctrine. That's where you'll find the code, the actual phrase, Clearfield doctrine. Just type that in Google. That code exists well before that stupid case where the Supreme Court, quote unquote, supposedly made a decision. Supreme Court, the Clearfield doctrine is not the Clearfield doctrine. It is called the commercial business doctrine. When government engages in commercial business, they willfully waive any and all rights to be sovereign. That's why they can be sued respecting their commercial business. So what the United States just did concerning China, Europe, and Canada is they just taxed those nations. Remember, the United States wanted Mexico to fund the so-called wall. Mexico said no. The United States said that they were going to get them to fund the wall one way or another. Excuse me, where is Mexico providing any funding? Exactly. Where is Mexico providing any funding? Exactly. You know what?
If I were to set up a kingdom, and it was in medieval times, my kingdom would be so situated because this would be my moat. This would be the way into the kingdom, and we would be set on high so that we could shoot down at our enemies, and our enemies would have to struggle to get to us. And we would be able to defend ourselves from the wall. Okay, see, they had a wall around their city, the way the United States putting a wall around its city. Remember, you could not, if the city's gates were closed, you couldn't leave without permission. The people in the city didn't have freedom. Well, ladies and gentlemen, they put that wall up. You won't be able to leave without permission. You don't believe me? You won't be able to get back in without permission. Don't believe me? Just sit back and wait. It's coming. And watch how rapidly they're going to put that wall up. Look at how many, that's where the employment is coming from. That's why they're increasing the employment, people, because they're hiring the workers to go out there and help build that wall. They need that wall. That's what they've been talking about. Are they going to implement their Agenda 21 plans and all that before the wall is completed? Of course they are.
And they're going to keep on working right through that process. Let's get back to the tariffs. Ladies and gentlemen, when you increase tariffs like they did on China and on Canada and on Europe, when you increase tariffs, you're now hearing them talk about it on the news. I didn't need the news to tell me this. I already understood how things work. They increased those tariffs, so what happened? Well, the moment they increase the tariffs, that means that those countries are going to pass that cost on to the companies that are providing the goods. When they pass that cost on to those companies, the companies are going to have to raise the price for what they're selling to the other country. The tariffs are the taxes. It's called international tariffs or international tax. That's what Puerto Rico's been going through. Puerto Rico, the United States charged an illegal tariff on Puerto Rico. See, Puerto Rico has a law called the Jones Act. The Jones Act says that everything in Puerto Rico must come through the United States. But when it does that, in order to get from the United States to Puerto Rico, it has to cross international waters. So it is charged a tax for crossing international waters. Fine. When that tax is affixed, it comes to Puerto Rico, and then the state, the county, and the local city taxes are applied. So now they get taxed, state, county, local, blah, blah, blah. But when a product is being sent out of Puerto Rico, it gets charged those taxes all over again, plus it gets charged the international tax for crossing international waters. Then it gets charged the tax from the state, local, and county government, as well as for the United States for coming into the United States. Nobody pays attention. And that's going both ways. So no matter whether it's coming into Puerto Rico or coming out of Puerto Rico, they get taxed. Well, every item coming in internationally gets taxed an international tax. Crosses international waters. Anything that travels more than 3 miles beyond the shore of America gets charged a tax. Whether it be Puerto Rico or Hawaii or the Samoa Islands or the minor outlying islands and all of that other bull crap, there's a tax charge. See, in the state, you have the impact, what is that stupid law called? See, I can't even think of it. And I was just talking about it the other day. And it's the law that allows the states to trade between each other. And I know what it's called. I just can't think of it. The words are not coming together. Oh, interstate compact. I said impact. Interstate compact. Interstate compact allows the states to trade with each other, allows people to go from one state to the other and buy things and come back to their state with the item without being charged for bringing the item back into the state. Okay? That's the interstate compact. They came up with that purposely because it was a taxation issue. Well, ladies and gentlemen, remember, they passed their so-called tax bill at the end of the year. Remember, they rushed it. They had to get that bill passed. It had to be passed December 23rd. It could not be passed the following week. It had to be passed then, and it was necessary. Congress was going to shut down the government and do everything else, but they were going to pass their tax bill. Trump, that was his signature legislation. So they decreased the taxes on all of the corporations. Why? Well, ladies and gentlemen, because they knew China and all the other nations were going to raise their tariffs, raise the taxes on American goods. So what did America do? America lowered the tax rate on all the corporations so that when that happens, they would not be hit as hard. Trump just announced last Thursday, and this is Monday, the 2nd of July, he announced that the government has made over $500 million thus far. Or $500 billion. Those were his words, not mine. Said the government made $500 billion. Where's that $500 billion going? Did he say it was going to needy families? Did he say it was going to help bring down the national deficit? No, he didn't say that, did he? Go back and listen to him. He didn't tell you where that money was going. Oh, that money is going to build a wall and build a bunch of other things that he does not have the ability of putting in the budget and getting approved by Congress. look, he's the executor. That money is tariffs that they are assigning, and they get to proportion where it's going. Remember, they need the money to build the stupid wall. But, pay attention. What happens? They said they were lowering taxes, so they called it a tax cut, the largest tax cut in history, which is not actually a tax cut because now you're hearing about inflation. Ladies and gentlemen, go and pay attention to the news. They're talking about inflation. If there was truly a tax cut and the economy is doing so well, then why are you worried about inflation? If the economy is doing so well, inflation should be going down, because that's less of a demand on the economy. Since the economy is doing so well, everybody's got a job, there are more jobs out there, and people are making more money because, remember, they just raised the minimum wage. Well, when you raise the minimum wage, you put a burden on these corporations. And most of the minimum wage is being paid to these major corporations who have all these employees, hundreds of thousands of them. Well, they have to offset that price somehow, so what did they do? They raised taxes by doing it in and around. You know how government does. They do doublespeak. They made you all think that they provided a tax cut, but yes, they did, to corporations and the wealthy. But what happens is now those corporations are going to pass those wonderful cuts off to you. So they're going to be paper cuts everywhere, ladies and gentlemen. How do we know this? Because you're going to see prices starting to go up. See, inflation means higher prices because they have to compensate. That's why the Fed raised interest rates. If the economy was doing so well, the Fed would not have to raise interest rates, people. If the economy was doing so well, they would not have to raise tariffs on China. Why do you think they put the idiot in office in the first place? So that he could do this and so that they could get this by you. But pay attention, I didn't do this. But ever since I did the video explaining to you about the tariffs and how it is a tax, all of a sudden it's on the news now and they're talking about the tariffs being a tax. They weren't talking about it before then. Everybody else was talking about China raising its tariffs on the U.S. and they were talking about a trade war. Nobody was using the word tax. Nobody was using the word it being passed on to the consumer. But they are now. I've watched several different programs over the past week. Well, no, last 4 days. And that's all they're talking about. I'm not saying they're doing it because I mentioned it on video, but I am saying they're doing it because people are now mentioning it, calling it a tax. And now they're mentioning it on the mainstream. But what are they going to do about it? Nothing. Nothing's going to happen. Nothing's going to change. The tariffs are going to stay in place. The people are still going to be taxed. You're going to hear about austerity. Remember, Germany just approved the Greeks' plan. What do you mean they just approved it? Remember, the Greeks went bankrupt. They're still in bankruptcy, ladies and gentlemen. Remember, they had their whole austerity thing going on where they lowered all of these programs. Remember, if the government was doing so well, if the economy is doing so well, then why did the new farm bill cut the social service programs such as food stamps? Food prices are going up, so why are you lowering the amount of benefits people get with food stamps? Nobody's asking these questions, but I am. Again, nobody's asking these questions, but I am. It's austerity. I apologize, but what's his name? Alex Jones did tell all of you guys about this 2012, 2013, 2014. I got to give him his credit as far as that. He did mention that that's what they were getting ready to do. Okay? I don't trust Alex. I think that he is a plant. I do not believe him to be legitimate. Sorry, it's just what I don't believe. I believe he's a whoremonger. Are you saying he's a whore? That's right. And he's a monger at the same thing. What you mean he a whoremonger? Yeah, that's right. He's among her and she's a whore. He's a whoremonger. Anyway, but he did tell you guys about the austerity programs. Ladies and gentlemen, that's just exactly what they're getting ready to do. Okay, and then when they implement the program where they cause people to get sick, it's going to start off slow. It's going to start off as scientists are working on this, and you're going to hear one report, and then they're going to stop talking about it for a while, and then you're not going to hear any reports. Then you're going to hear about, well, it's gotten worse. It just sprouted and popped up over here, and they don't know how this is happening, and so they're believing this, and they're going to give you all kind of distractions and all kind of guesswork that won't make any sense. You just need to pay attention. This is a plan. Donald Trump being in office, they were setting Donald Trump up for office ever since they gave him the show called The Apprentice. Let me point it out to you so that you get it. Go back and look at the last time you've seen pay attention, a business owner have their own television program. Not even Oprah had her quote-unquote business and had her own program. Phil Donahue? Nope. Johnny Carson? Nope. Each one of those individuals got started from the ground up. But Donald Trump, businessman who went bankrupt 3 times, and here he is having his own television show, The Apprentice. And did you notice how the ratings were so high and everybody was talking about The Apprentice at the time? Well, that's called hype. The same thing they do with recording artists. When the record industry wants to promote a recording artist, they talk about him all the time. Do you remember Taylor Swift? Taylor Swift is not all that great of a singer, but guess what happened to Taylor Swift? There is an award where everybody's watching the award, and Kanye West, not too shabby, is he? Kanye West gets up there and talks about how Beyonce was better than Taylor Swift, and the next thing you know, she blows up. You don't believe me? Go back and look at her so-called career. And notice that after Kanye West made that statement of controversy, because as Michael Jackson told you all publicity is good publicity. Kanye West took one for the team when he did that. Kanye wasn't crazy. Now, when he was saying the things he was saying, that's because people didn't follow through with their promises. And so he decided to be vocal about it. He just went about it the wrong way. But did you notice, right after he did that, 2 years later, he has the #1 selling album and almost gets Artist of the Year and all this other stuff? He got rewarded for what he did. And then he marries Kim Kardashian. You heard me, Kardashian. Okay, because she done slept with so much and so many that if bed bugs ain't the offspring that she produces, I don't know what she doing. Okay. That was all for show, ladies and gentlemen. That's the system. And you just have to sit back and pay attention. You just have to ask yourself, pay attention, why did Kanye West do that? Beyonce is not that great of a singer for him to be sitting up there talking about Beyonce should have gotten the award. All you got to do is sit back and listen to what they're doing. It's all scripted, but it's all meant for the simple-minded, the people who will just accept something because somebody said it. And so that's what happened at that point. Like I told all of you, the video production and things are going to slow down because I'm tired. See, I put out so much information that by now people should have gotten it. But no matter how much information I put out, people still want me to give them everything. Everything! Everything! And it ain't going to happen that way. Ladies and gentlemen, it's not my responsibility to, I want to hold your hand. No, it's not my responsibility to hold your hand. Okay? I am not here to hold your hand. I'm not here, let me show you the way. I'm not here to show you the way. That's not my job. That was never my job. You see, I only volunteered to help out a couple of people along the way. I didn't volunteer to help the whole world. Okay? I'm not here to save the cheerleader. Save the cheerleader, save the world. I'm not here to save the cheerleader, people. And so I have sacrificed. I've given my time. And I've given enough. And I'm saying I'm going to decrease The other people out there can increase. You guys can listen to them. I've just showed you how to go through a document and get rid of all of that speculation and all of that hearsay and all of that statements and all that. Ladies and gentlemen, if somebody makes a statement, if somebody says something as if it's a fact, and you'll see judges do this all the time, you must challenge them on their statement. I just had somebody, an attorney, tell me that he was in court and there was another attorney, and the attorney told the court, well, such and such, such and such, such and such says such, such. And the court says, well, where's that statute? Where's that cite? And he says, well, Your Honor, I don't know where it is, but it's a matter of public record. Excuse me? I don't know where it is. It's a matter of public record. Well, then, fool, if you don't know where it is, then you can't put it on this public record. You can't put presumptions on this record. No, I object. The other party objected, but they didn't object according to the way the court wanted them to object, and so the court accepted the junk. Ladies and gentlemen, an attorney represents a client. They're not allowed to make statements in court. Attorneys cannot make a statement. Their statement is on behalf of their client. They're not there representing themselves. They can't speak on behalf of the court, even though they're a court officer. So who is the statement representative of? It cannot be representative of the attorney because they cannot testify and or make statements in court. They can only represent their client. Well, if their client is not there, they can't speak on behalf of their client. You have to object to that bull crap. But you guys are not doing that. By the way, the prosecution is said to represent the people of the state of California. Okay, well then, where are its people? Because if the prosecution is there representing the people, then that means everything the prosecution is saying is testimony, is under oath. Because they took an oath of office and they represented the people, they cannot do that, people. There is no law that allows them to represent the people without the people being present. If they're going to speak for the people, then it would have to be the people. And if the prosecution is saying it, then it must be some basis for the statement. So if the prosecution is saying the people does this, the people does that, where did you get the approval and or the agreement of the people to do that? Well, the law, the statute, no, the statute allows you to do that if you're operating in your official capacity, but you're operating in a corporate capacity. Okay, but you guys can't have that argument unless you can explain it. See, I can run it down to them. I can have my challenges. This is the stuff you all need to be practicing on. This is my life, ladies and gentlemen. I sit back and I think about a court case. Remember, I told you I used to go and sit in court for hours. Just going in and sitting in regular superior court. I would just go there. I'd have nothing better to do, especially if I had a case coming up. The same as I would do if I was preparing for a basketball game. And I have my team, and I'm coaching them, and I'm preparing for a basketball game. Especially if we're in a tournament, we would go and watch the games. We would get there hours early. Our games would be later in the day. We would get there at the very beginning, and we'd watch the teams to see whom we were going to play against. Because we played against them during the season, but now we need to know who the coach is going with, who they're leaning on, who their best players are. Well, ladies and gentlemen, I would go to the court and do the same thing. Why? Because that's been my routine. You must know your enemy. Know thy enemy. And so I would go to court and I would just sit there in the audience and I would listen to the judge and listen to the attorneys, pick up on some phrases and some techniques. That's where I got most of the understanding, people. Is I monkey see, monkey do. I copied those idiots. And, there were some stumbles, but after a while I had some success. So I started hanging on to success and started listening to more. And guess what? I got to see what the judge would say. I got to see where the judge was, oh no, you can't say that. See, judges give presumptions. They're not allowed to presume from the bench. Not while they're under oath. The oath does not permit them to hear hearsay. The oath does not permit them to hear fantastical arguments. The oath that they take does not permit them to hear anything other than facts. They cannot hear a presumption. That's why you have to challenge that. Your oath of office does not allow any avenue, any room for a presumption. This is a court of law, which means you cannot entertain theories. You can only entertain facts, and only facts can be presented to the jury. You cannot present,
Well, I believe that Martians exist and that they have existed all of this time and they live here amongst men. I also believe that in the center of our earth there is a whole cavern of caves where there are these wee people, and these wee people have lived in these caves and they live underneath the earth, and there is no hot molten core, and the fact that we have volcanoes does not suggest that there's a hot molten core. It only suggests that the volcanoes exist, but not that there's a hot molten core. And
you see, ladies and gentlemen, you cannot introduce a theory in court, but they theorize all the time in court, and nobody challenges them on that. Go and look at the oath of office for the judge. Notice how they have to uphold the Constitution. The Constitution is a factual document, not based on a theory. But because they operate under an administrative capacity, the administrative law lets them deal with theory. Got to challenge that bullcrap, ladies and gentlemen. You got to challenge it. All right, that's the information I wanted to give you guys. It's taken me an hour. It's 9 a.m. in the morning. I'm about to leave all of you to your day, and I'm about to get back to doing what I'd do. Mind my own business and take care of my own issues. Have a good day, everyone. Goodbye! Wrong button. If I do that, it definitely won't work. I got to hit this one.